Hi everyone, welcome back to my channel. This series is about the civil procedure cold call preparation. And today's case is In Re Bath and Kitchen Fixtures Antitrust Litigation. Okay, so the introduction of this case is, so here will be the case name is In Re Bath and Kitchen Fixture Antitrust Litigation. And the court is under the Third Circuit Court of Appeals. Judge is Sirica, and it happened in 2008. The relevant rules are Rule 41A1AI. It's about the plaintiff's right to voluntarily dismiss an action. And also the rule we learned before. So that's a Rule 12B6, motion to dismiss. Okay, so let's take a look of the procedural posture. How did we get here? At the beginning, the plaintiff filed a class action sue the suppliers, manufacturers against the antitrust law. And the defendants responded with the 12B6 and alleged that the plaintiff's complaint is not sufficient. And the district court agreed the complaint lacking sufficient facts under Rule AA2, and the court required more factual specificity for plausibility. But before the court entered the final judgment, the plaintiff filed a notice of voluntary dismissal under the Rule 41A1AI. And of course, the defendant objects the final judgment, object and asks the court to strike the notice dismiss the case with prejudice. And the district court did strike the notice as untimely and dismissed the case. Here, the plaintiffs appeal to the Third Circuit. The issue we're going to discuss today in this case is whether the plaintiff has the right to have the notice to dismiss the case voluntarily without the court's discretion. And the application rule, applicable rules in these cases are the first one, Rule 41A1AI, voluntary dismissal by the plaintiff. So the rule governs in this way. The plaintiff has right to dismiss the case and file the notice to dismiss the case without prejudice, without the court's order, before an answer or a summary judgment has been served. And of course, the dismissal will be without prejudice, unless the plaintiff previously dismissed an action on the same claim or the notice states otherwise. But we need to know that the reason why eventually the court was on the plaintiff's side is Rule 12B6 motion to dismiss is not an answer or is not a summary judgment. It does not cut off the plaintiff's right to voluntarily dismiss. The second rule applicable here is the Rule 12B6, motion to dismiss for failure to state a claim. This rule we have discussed earlier and requiring the legal sufficiency, not factual truth. And if granted, it usually leads to dismissal without prejudice. The reasoning of the court is specifically basing on the rules. The Third Circuit sided with the plaintiffs, emphasizing the automatic nature of Rule 41A1AI. First of all, the rule gives the plaintiff absolute power to withdraw the case before served any answer or summary judgment. And here in this case, the defendant did not serve answer or summary judgment. The defendant only filed a motion to dismiss the plaintiff's complaint under 12b-6, but there's no summary judgment or answer. Therefore, the plaintiff notice was valid and self-executing, and immediately terminated the case without any need for judicial approval. And the Third Circuit believes that the district court does not have the authority to strike the notice. The court also noted this procedural rule saves judicial resources by allowing plaintiff to voluntarily end weak cases early without forcing courts to issue unnecessary rulings. The holding a position, and eventually the Third Circuit vacated the district court's order striking the notice and remanded the case with instructions to enter dismissal without prejudice under Rule 41A1AI. The policy behind these rulings is, first of all, judicial efficiency. So it will provide the freedom to the plaintiff to withdraw any unnecessary claim without wasting the court's time. And second one is the plaintiff autonomy. And the plaintiff should have the control to decide whether to proceed or to withdraw the case. And the last one will be the strict textual application. Reinforce the mechanical nature of Rule 41. And if the conditions are met, dismissal is automatic, not court discretion involved. So the bar exam and class tip. When we're doing some bar exam, how do we apply the rules here? The first one is 12b-6 motion does not terminate the plaintiff's right to voluntarily dismiss. So we're seeing, when we're seeing the hypo, we're going to see if the defendant files a 12b-6 motion to dismiss, and then the plaintiff filed notice to dismiss, and who is going to proceed. And but if the defendant files a motion summary judgment or answer, so and it will terminate the plaintiff's right. Watch for this pattern. If you see a question where a plaintiff dismisses after a motion to dismiss, but before any answer, the correct outcome is automatic dismissal without prejudice. So here will be the quick hypo. Plaintiff sues defendant for breach of contract. Defendant files a 12b-6 motion before the court rules. Plaintiff files a notice of voluntary dismissal. And is the notice of voluntary dismissal valid? Yes, it is valid. So, and is it with or without prejudice? It will be without prejudice. And does the court need to approve it? No, it is automatic. The summary of this case, the name of the case is In Red Bath and Kitchen Fixture Antitrust Litigation from the Third Circuit, happened in 2008. The key rules are Rule 41A1AI, voluntary dismiss by notice, and holding. The plaintiff notice was valid because the defendant hadn't filed the answer or summary judgment. And take away, a motion to dismiss under Rule 12b-6 does not cut off the right to voluntarily dismiss. The dismissal is automatic and without prejudice. Here will be everything for this cold call preparation, and I hope you like the way to study. So if you like this series and my channel, please subscribe, and then I will work with you in another case. Thank you.